Ms. Bunn?
Good afternoon. So I just want to say that my experience in the aggregate mirrors the results of the research conducted by Dr. Bronfenbrenner in terms of the timing of employer knowledge and the testimony, compelling testimony of workers and their representatives in terms of workers' experience during organizing campaigns. I have nothing additional to add, but would be happy to answer specific questions. We support the proposed rule.
And I also just wanted to make a couple of really quick points that are different from, or I guess in addition to what has already been said repeatedly this morning and afternoon. Just simply the idea that employer rights are somehow being impinged by a potential condensing of the election period. Again, that's sort of premised on this idea that employers don't know about the campaign until the petition is filed, and as Professor Bronfenbrenner and a number of other people pointed out, that simply just doesn't seem to hold up in reality. In addition to that, that survey that I had mentioned yesterday, 82% of the attorneys who responded reported that they counseled at some point on an organizing drive where the employer knew of the drive prior to the filing of the petition. 78% report counseling on drives where the employer began its anti-union campaign prior to the filing of the petition. And if you're looking for more examples, you should just look at your own case law. You issued one of the most recent published decisions you issued was Lucky Cat, which you issued in the end of February, a decision that was fairly unremarkable, no offense.
We've already been told that what we're doing is very easy, so you don't have to repeat that.
So much so that I doubt most people here even read it.
I was not on that panel.
That's why it was so unremarkable. But if you look at the facts, the union filed this petition on March 30th, but it informed the employer of its organizing activity on February 25th. And the board found that the employer knew of the organizing drive for months prior to that because employees solicited cards openly in front of supervisors in that case. And I'm sure if you went through your cases, you would find many, many similar examples.
Right, but just to follow up, I think I may have been on that panel or not. At this point, it's all a blur. But
you're remarkable.
At the end of the day, what should we be regulating to address? I mean, that kind of surfaces the question. Let's say that we all have varying views on what percentage of the time employers have advanced knowledge. I would gladly agree with you that it's well north of 0% of the time. But are we basically going to regulate the entire community, assuming everyone has foreknowledge, when even your own survey says that 22% of folks don't have knowledge?
I would say that in no way are these rules regulating speech. They don't address content of speech in any way. And on top of that, they don't address the ability of the employer to speak at any time prior to the day the election's held, or other than the ways that the board has already said that they're limited. The employer can begin speech, and people have testified about examples where employers begin their speech from the day the employee is hired. Nothing prevents the employer from beginning its anti-union campaign at any time. And therefore, I would say that in no way are these rules regulating speech.
Right, but just to be intellectually clear here, the idea that an employer is going to put in its handbook, for example, some language to the effect of we don't want a third party here or we don't like unions or whatever the case may be, that's not a campaign in the sense of here are 7 or 8 different campaign issues about higher wages, better health benefits, what happened at other plants, things like that. And so I think what we're trying to grapple with here is not shutting down that discussion getting joined on specific issues that actually happen in a campaign, because I think you and I both know that campaigns are more sophisticated than simply a union would be a great idea for you, a union wouldn't. That's the end of the conversation. And so I'm wondering if the AFL-CIO has ever done any studies on basically what stages a campaign goes through, what kind of communications go back and forth, and how long does that process take? Do you have anything like that?
Can I, if I may, just say a couple of things in response. First of all, there's been several references during the day to the union as the third party, And what a union is a group of workers who want to collect.
Right, you're the exclusive bargaining representative representing the workers, okay?
And I think there have been, a number of comments here when you have asked questions to workers about the union this and the union that, and their response is, well, the organizing committee, we talk to our co-workers. So I think I think it's important to make that distinction. But the issue of the timing, which I think what you raised, we both addressed that, and several other people have, because the employer community has suggested that the first time it has knowledge that its workers are organizing and want a collective voice is when the petition is filed. So those comments really were to address that as a factual matter, that's really untrue. But more broadly, I think the point is that employers communicate with their employees all the time, all day, every day, and they have complete control over that communication.
Right, but is that the relevant question in terms of just simply having the right or the power to discuss or communicate generally versus the actual freewheeling, robust debate on a specific set of campaign issues? That's what I'm struggling with. And do you have any research on that?
Yeah, the only research I had was from an employer lawyer who said first week, third party, second week, dues, third week, strikes, fourth week, please give us another chance. And that came from an employer lawyer.
But was that right after the petition was filed?
No, he was saying that's the handbook that persuaders.
So they put all that in their employee handbook?
No, but on a more serious note, the answer is yes. I would say two things. First of all, yes, in answer to your specific question, all of that time that the employer has to communicate has to be part of the discussion of whether there's the right to free speech. And secondly, I understand, and I really do understand the Supreme Court's rulings about robust and free speech. But please understand that as a legal matter, I understand that. But as a practical matter, workers in the workplace don't have that robust debate. They have one side from the employer, day in, day out. One case that I was going to raise, but in the interest of time didn't, there was a campaign very recently, 3 weeks, 25 days, and 8 employees, 30 individual captive audiences, 30 in 3 weeks. They actually wrote a petition saying, please stop. We understand your point of view. We've heard your point of view. We have plenty of information. We're grown-ups. We can make a decision. And nonetheless, the captive audience meetings continued. So there's just ample opportunity all day, every day.
Right, and I think campaign fatigue could be an indicator of that. I guess, did you ask any questions in the survey about the campaign fatigue question?
No,
Okay.
Honestly, that's a question. That's a concept conceptualized, I guess, to me afterward.
Okay.
Now, there are several of us here that would have different views relative to whether or not a union-free workplace publication and employer's handbook constitutes campaigning. But my question is one that I've asked before, and that is, these conversations have been focused on time. Is the opportunity for communication to the employees impacted by technology, and does technology should technology should we be sensitive to technology when we're talking about opportunity and time in terms of communication to the employees?
I would say yes, as several other people have said also. Increasingly, we're seeing employers communicating with their employees on campaign message through the internet, through emails, and even through texts, as one of the workers said. And this, of course, the speed of that is remarkable.
I would just add, in one recent high publicity campaign that I'm aware of, employees were provided anti-union videos on flash drives so they can take them home and watch them. And that election took place in a very short amount of time. Less so than what people are saying the proposed rules would create, the timeframe they would create.
So anti-union flash drive would happen a lot quicker, you're saying, than a captive audience speech?
Yeah, oh yeah, right. I think what you're saying is that technology can speed up all of this communication. I think that's absolutely correct.
Okay. Thank you all.